Justice Jackson?
So I guess I don't understand how on remand the Seventh Circuit could make the kinds of determinations that you said that they could make in response to Justice Gorsuch. And the reason is because we had a trial in this case. We had a trial in which presumably those very same arguments about what the statement meant to your client, what the bank examiner said, et cetera, were evidence that was presented to a jury that was then instructed that they were supposed to make a determination about whether his statement was false, right?
That's correct, Your Honor.
Okay, so why isn't the Seventh Circuit's only potential response on remand to determine whether any reasonable jury, given that set of circumstances and evidence, could have reached the result it reached? I don't think the Seventh Circuit could just pretend as though the jury didn't make a determination in this case and answer the question, does it think there was a false statement here, right?
That's right. I think that it's very likely that the Seventh Circuit would remand to the district court that heard the evidence, and there is a very exacting standard, as Justice Jackson, as you know, for a motion for judgment of acquittal. And
so help us to understand whether all of that is really not necessary, because it's pretty clear that a reasonable jury could have made this determination. What is your best argument as to why, for example, and I'll just give you the analogy from the government, the analogy about the kid in the cookie jar, that the mom says, how many cookies did you eat? Or did you eat cookies? Or whatever the question is. And the kid actually ate, and I'm now making this up, 10 cookies. And he responds, I ate 3. Why is that not a false statement?
Your hypothetical, the answer to your hypotheticals is actually twofold. If the mom had said, did you eat all the cookies? Or how many cookies did you eat? And the child says, I ate 3 cookies when she ate 10, that's a false statement. But if the mom says, did you eat any cookies? And the child says 3, that's not an understatement in response to a specific numerical inquiry.
All right, so here's the question here. The question, I guess, in response to that answer is, why wouldn't it be reasonable for a jury to interpret the submission of the invoice to be the kind of specific question that would require him to provide an answer? I mean, we don't have a particular question. We have his interpretation of the question and then answering it in a certain way, which you say doesn't make it false. But in the context of what a reasonable jury could have determined, I don't understand what your argument is to why a jury couldn't have interpreted what happened here to be calling for a specific response to the question, how much do you owe?
Well, I think it's difficult to conceive of an assertion in an invoice as being a specific
difficult,
numerical.
But impossible. The question is, could a reasonable jury have interpreted it that way?
I don't think so, Justice Jackson. And the reason is, among others, that there wasn't a question posed at all. The witnesses testified that he was, or the evidence showed that he was talking about his personal note, not the total amount that he owed. And the government conceded that what he said was, and I quote, literally true,
all right,
but not the whole story.